Approximately 55% of all federal funded research is conducted by universities. I believe it is in the taxpayers' interest for the research to be developed into products or processes rather than to be underutilized. And I think you probably agree with that too. The discoveries made at our universities can often be eventually commercialized, but they are patented to protect the investment in development. There have been concerns that some legislative proposals may inadvertently define the universities as patent trolls. I'm confident that this legislation before us does not go that far. With that understanding, will you please discuss how this particular draft bill distinguishes between those who send out large numbers of letters merely seeking payoffs and legitimate large-scale patent defenders like our university systems? And we can start with Mrs. Greisman, if she'd like.
I think it directly does in one way by speaking in terms of pattern and practice, because it is enforced by the FTC Act. As I mentioned earlier, the FTC Act can only act in the public interest. So that is another constraint on what we could do vis-a-vis enforcing the law, the proposed bill.
And I would say the enumerated provisions.
Is your microphone on?
I'm sorry, thank you. The enumerated provisions are going to focus attention on the bad actors, not the people who are legitimately enforcing their patent rights. And the Vermont law that was enacted a year and a half ago specifically addresses the university situation. This one does not, but I think in any event, the universities are not going to be sending out the kinds of letters that are described here in Section 2. And could I say one more thing about a comment
Sure.
that Mr. Mosoff made? He said that there was a Vermont case that struck down compelled speech. It was not compelled speech. It was, in fact, exactly the opposite. It was speech. It was a provision that did not allow certain accurate information, so it's not like what you're dealing with here with deceptive information. It did not allow accurate information to go to some people while it did to others. It did not allow it to go to marketers while it allowed it to go to universities. So I just wanted to clear that up with regards to the Vermont case. Thank you.
In fact, thank you, Ms. Morgan. You preempted my correction. I checked my notes because I was speaking extemporaneously when I answered the question earlier to the congressman. But yes, it was a restriction on speech that it was struck down. It was a commercial speech case, and so it's a very significant case that indicates that commercial speech is still given much greater scrutiny now than it used to receive.
Thank you.
So I apologize for that misstatement earlier. But to go back to the question that was presented to the panel, I believe that the question is very well made, Mr. Congressman, because universities, because they license and don't manufacture, are accused of being patent trolls. And for instance, University of Wisconsin, its tech transfer division, WARF, is often listed as one of the, quote, top 10 patent trolls in lists that you see on the internet for enforcing its legitimate patent and innovation from Wisconsin researchers against infringers. So I think this is a real concern, and that universities and individual inventors have been brought within the scope of this pejorative term patent troll. And if you don't have actually specified lists of what type of activity you're prohibiting, you risk creating the types of damage to the innovation economy that Mr. Rogers has detailed, I think, quite well with respect to good inventors and original inventors, because a lot of our original even large companies today, like Google and Microsoft, Apple, and Hewlett-Packard, started in garages and were individual inventors. In fact, Google, they were university graduate students at Stanford when they came up with their algorithm. They got a patent on it and received venture capital funding.
Thank you.
I agree with you that the bill does a good job in avoiding putting universities into the same category as patent trolls. The statute appropriately does a lot to limit the application of the bill, does a lot to limit its application to patent troll activities and not to legitimate enforcement behavior. There's a belt, there's suspenders, and something else holding up your pants. I mean, there's pattern and practice limitation, there's the bad faith limitation, and there's the user agent model. And I think I think under all those, the universities would probably not be involved in this.
I agree that there are clear distinctions between good actors and bad actors, but I don't want to leave it unstated that universities do have the potential to send out a pattern or practice of deceptive demand letters. And in those contexts, let's remember that universities are taxpayer funded, patents are a gift or it's earned, but taxpayers are the beneficiary through the government and the PTO of the patent, and we should make sure that everybody is a good actor. So I appreciate that as a general proposition, universities are not in the business of patent trolling, but that doesn't mean we should have clear distinctions if we're defining what's good behavior and what's bad behavior.